on the subject, just an illustration of just how really a game changer the California Consumer Privacy Act is. So first I want to give a real big shout out to our new platinum investor, Miller Kaplan. They've made a major contribution to SecureTheVillage, and we're incredibly grateful to them for that. So this month we've got two guests, both from the law firm of Buchalter, Matt Seror and Weiss Hamid. And Matt, Weiss, you want to say a couple of words about who you are and kind of the way you look at this landscape? Matt, go ahead.
Yeah, no, of course. Of course. Thanks, Dan. My name is Matt Seror. I am in the litigation group here at Buchalter. My practice's focus is on complex commercial litigation, intellectual property litigation, and increasingly data privacy and specifically CCPA compliance issues, counseling clients. It is an evolving landscape, as we're going to touch on today. And it's something that I think everyone needs to stay kind of abreast with because things are changing. So I'm looking forward to our discussion.
Cool.
Hi, I'm Weiss Hamid. I'm an associate here at Buchalter in the civil litigation group, as well as do data privacy, data breach response, and compliance work when it comes to making sure that companies are complying with the new CCPA law.
Cool. Well, we're grateful to have both of you here to share your knowledge with us on this very much an evolving subject as we're going to talk about today over the next hour. Here's a general outline. We're going to be talking about a lot of things. I mean, this California Consumer Privacy Act, obviously give an overview of that, look at liability impacts from the California Attorney General, the whole issue of private rights of action of California Consumer Privacy Act. I think as we've talked about in the other webinars, and just as I'm out talking to people, I mean, this private right of action is a real game changer in the privacy landscape, if you will. Contract languages, statutory damages for data breaches. And again, with that clause, reasonable practices and policies, we're going to drop down and look at that a bit. And then the relation to other California laws. This is not just the only law requiring security plans and other kinds of security behaviors on the part of businesses. So we'll get into that as well. And just to start off, let's give a brief overview of the CCPA, and go ahead, jump in.
Yeah, thanks, Dan. So, you know, as many people on the line are probably familiar, the CCPA was passed a while back, became effective beginning of this year. It's intended to provide California consumers with transparency and a variety of options with respect to their personal information, how it's collected, how it's used, how it's retained, things of that nature. Among other things, it provides consumers the right to opt out of having a business maintain their information. It allows them to know what that information is being used for, and provides various protections. Businesses cannot, discriminate against them if they do decide to opt out. That is their right under the law. Stan mentioned this briefly in his comments just now, but the CCPA also does create a private right of action. It's a limited private right of action right now. We'll get into that, but there is that private right of action, which I think could lead to litigation in the future. We'll certainly see, and the provisions of it which allow the Attorney General to kind of step in and provide guidance on it. The latest guidance from the Attorney General actually just came out last night, so still digesting that, but that's something else that the CCPA provides.
Yeah,
exactly. Weiss,
and when it comes to, there's also issues, especially when it comes to the CCPA with respect to its relationship with other data privacy laws. Currently, there is no official federal data privacy law. We don't anticipate one happening in the immediate future. However, Congress has been toying with one. There's also the European Union, the GDPR, which a lot of companies that, especially multinational corporations that comply with that attempt to comply with the GDPR, its relationship with the CCPA. For example, while there are certain similarities, like for example, the right to delete and the right to request what information they collect about you. There are some unique aspects to the CCPA, specifically when it comes to the opt-out procedure and what opting out of a sale of your personal information, which is an issue we're going to touch on a little bit later. And then there's also the Gramm-Leach-Bliley Act when it comes to financial information, and then HIPAA when it comes to medical information. So it's fascinating to see all of these different data privacy laws and their relationship with each other.
Yeah, no, I find that a fascinating piece as well. I mean, when I started, it wasn't a matter of law. There was Defense Department directives around securing classified information, and so that was the world we lived in. And there, correspondingly, in the commercial sector, there were banks and insurance companies that were beginning to look at not the legal side of this, but how do we protect ourselves against, for example, consumer fraud and those kinds of things. Then we got the first law that I recall was, mid 80s. It's made it illegal to breach another system. And then we got the breach disclosure law starting in 2005 or something with California. And now here we've got a patchwork of laws around the country. We've got GDPR, we've now got CCPA, we've got other states with also privacy laws and so on. And, just from my perspective, not being a lawyer, looking at, how complicated this has become for, and you guys got to live day in, day out in this space as you've got clients around the country, around the world, and so on. So I find this just an amazingly complex challenge to get one's head around. It's partly why this is the fourth webinar on this subject, just because it is so complex. But one of the things you mentioned, and I want to jump into that right away, because I think it's so telling, is the guidance from the California Attorney General. I mean, Matt, you mentioned we just got, we wrote this slide, we finalized the slide yesterday during the day. Later in the day, the Attorney General came out with yet again new guidance, updating the old. So let's talk a bit about this whole subject around, what's going on? What can we expect? Where's the certainty, if you will, in all of this?
Well, I think, Stan, I think what we can expect is uncertainty, right? I mean, you mentioned it. I mean, we talked yesterday afternoon and thought we were all ready to go, and then after we spoke, there was new guidance. I think part of the issue here is the CCPA was passed almost 2 years ago now, and it was passed, as far as legislation goes, very quickly. It was rushed through the California legislature because they were staring at a ballot initiative which was going to be put on the November ballot, that upcoming November. And the thought was that ballot initiative may have passed, and it created some really tough regulations. So the legislature wanted to try to avoid that. So to avoid that, they pushed through the CCPA. And as a result of that, there weren't a lot of details, right? Some of that vagueness remains, this reasonable language we'll talk about, but a lot of the other details were not in the statute. So I think they kind of deferred to the Attorney General to provide this guidance. The Attorney General has done that, continues to do that. The guidance is susceptible to public comment before it gets adopted. So it is an evolving process, and we still don't exactly know what that final guidance will look like. So there isn't a lot of certainty.
Yeah, in fact, there was the first set of proposed regulations that occurred towards the end of the year, around December. Then in February, they released revised versions of them, which struck out certain segments of that proposed regulation and then added more. And then, yeah, to Matt and Stan's point, once I came back to my office after our meeting, I got an alert indicating that there had been a second proposed revision to the proposed regulations. And when I clicked through and I read through it, they had struck out some of the language that was done in the February proposed regulations. So all this does is just indicate that the law is still in flux. We're, of course, still advising our clients in ways to ensure that they're complying with the CCPA, but with an understanding of, hey, certain obligations that we are required to do right now, come 2 months from now, it may or may not be there anymore. In fact, after this second set of proposed regulations, they've now opened up for additional public comment. So we are evolving the way as much as the law is.
Yeah, we definitely are. And I don't know if it was in yesterday's, I've not seen yesterday's announcements at all, but one of the things I noticed was missing from the first two sets was any discussion of any regulatory discussion around what reasonableness and security practices has to look like. And I can kind of understand putting that off till later because there's all this other stuff around, being able to opt out and so on that you got to get right first. But we, SecureTheVillage, participated in one of the hearings in Los Angeles around the minimum, our idea, we'll talk about later, the idea of reasonable security practices. So I'm always looking forward to, okay, when's the Attorney General going to opine on what those things have to look like? But what do we do know now? I mean, as far as we know, what we've got on the screen right now is still more or less what we can expect. I mean, is that kind of your sense?
Yeah, I think that's right. I think for now, I think this is what we can move forward with. Specifically, there's some time frames within which businesses need to respond. I think that's something that is valuable guidance, right? Because that's concrete, real-world stuff that you need to comply with. While there isn't language in flux, the second bullet point, the CCPA needs to use straightforward language that's easy for every average consumer to understand. That's not going to change, right? That's going to be in any final version. Verifying that consumers are actually the ones who are asking, that's going to be in any final version. So some of that baseline stuff, I think we'll see. I think some of the detail, some of the minutia may be a moving target a bit as we move forward.
Mm-hmm. Yeah. Weiss, any other thoughts on this slide before we move on to the next?
Well, just echoing Matt's point, I think there are key components of the motivation of the legislature in terms of certain rights of the consumer that are being protected. And so the rule of thumb is always just to make sure that you're doing the best that you can with the information, with the data that you currently contain.
Mm-hmm. Yeah, I think that's a good point. Just, given how much flux there is, just do the best you can as you're moving forward with all of this stuff. And I guess to that same point, the better you understand the context in which all the flux is happening, the better you're able to provide guidance to your clients as to how do you navigate this appropriately. I mean, your point, Matt, that some of this is not changing. The need for straightforward language, I mean, I see that everywhere. Again, not as a lawyer, but as a consumer, when I look at laws and things like that. So yeah. Let's move on to the contract side.
Making sure that making sure that your privacy policy and your terms of service are something that anybody can understand is probably a focal point in terms of providing a consumer an understanding of what's being done with your information. That's not gonna change.
Yeah. That's certainly true. Okay, let's move on to the contract side, and it lives so much of it in the language of service providers. So why don't one of you just kind of talk us through what this slide's all about?
Sure. So as we discussed a little bit earlier, one of the key components of the CCPA, in fact, a component that's pretty unique even compared to the GDPR, which is also a wide, gigantic law, is the concept of the ability for a consumer to opt out of a sale of their personal information. And so with that raises the question of, well, so going to the specific language of the statute, which is the first bullet point, a consumer shall have the right at any time to direct a business that sells personal information about the consumer to a third party not to sell the consumer's personal information. That's referring to opting out. Now, that raises the question of, well, what exactly is a sale? Because a lot of businesses and a lot of companies who are handling and processing personal information instinctively don't think that they are selling that personal information, because the way that we traditionally understand sales is if I give you a product and then you give me money for that product. Well, technically, I'm not really receiving money specifically for giving them my consumer's personal information. However, if you look at the second slide, the way that the CCPA defines sale, it's a little bit more broad than just simply an exchange of the information for money. It's selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating orally, in writing, or by electronic or other means, a consumer's personal information by the business to another business for monetary or other valuable consideration. So some key language in that there is, one, making available. So it's not even just transferring, but just even making it available. And then lastly, it's for monetary or reasonable consideration. So with that, there are a lot of relationships that you have with your vendors. Let's say that you're a business. There's a lot of relationships that you have with your vendors that you may not realize at this time involves the sharing of your consumer's personal information. And more importantly, there's a lot of relationships which the sharing of that personal information is pretty vital to that relationship with that vendor. And we outlined a couple examples of this. So for web hosting providers, data analytics providers, and cloud storage providers. So I'll just take that second one specifically. So if you were working with a data analytics provider and you're providing to that data analytics provider where your consumers are purchasing, let's say you're an online retailer, and you're showing that data analytics provider the information, and they're able to generate for you a report so that you can understand what is selling popularly, where are your clients going in terms of navigating through your website, as a way to improve your website and also improve the products that you're trying to sell to your clients. If your consumers have the ability to opt out of that opportunity, it really does frustrate your ability to get an accurate detail in terms of what your consumers are actually doing. And so you want to make sure that you determine which kinds of businesses an opt-out would make the business a little more difficult. And the reason why you go through that analysis is that because, according to the fourth bullet point, there is an exception that a business is not selling personal information if it shares it with a service provider. And so that's why that leads to the big question is, do I want this specific vendor to be a service provider? Now, and when you do that, once they are established as a service provider, then consumers aren't opting out of that information, and that way you can continue to share that information with that service provider. Now, in order to get that established, two conditions must be met. The business, meaning your company, needs to provide notice that that information is being used, and then you need to identify that in your privacy policy. Second requirement is that the service provider does not further collect, sell, or use the personal information of the consumer except necessary to perform their business purpose. Now, that goes to the core of what the CCPA is, which is that California wants to make sure that if my company is sharing the consumer's personal information, that then the next company doesn't sell that information to somebody else, who then sells it to somebody else, who then sells that to somebody else, and all of a sudden, us as California residents have our information all over the place without our knowledge. That's the main purpose of the CCPA. That's what it's trying to prevent. So if you have within your contract outlined with your service provider that I'm giving you this information for you to create this report, and once you provide me the report, that's all you're doing with that information. You are not going to take my consumer's information, and you're not going to then sell it to somebody else to sell to other marketers or advertisers or anything like that.
hmm So then, if I understand it right, the issue is, so I'm a business. I've got a relationship with, whether it's maybe my web hosting company, maybe I've got my stuff in the cloud, a lot of consumer information there, and whether it's, Microsoft or Google or whoever in the cloud. It's like you said, a data analytics provider. I'm sharing information with them for the purpose of benefiting my business relationships, my business structure, how I want to optimize what I'm able to do. I can do that without running afoul of the opt-out clause if then those two things that you mentioned are true. One, I got to identify it in my privacy policy, the specific. I'm sharing information with a service provider XYZ. And second, I've got to have some kind of contractual relationship, I would assume, then with that service provider, that they're not going to do anything with that information except use it for the business purposes that I've specified. Is that kind of
Yeah,
the right
that's
analysis?
essentially what the whole service provider requirement is intended for, and that's what it's meant to be. Because making sure that you have making sure that you even have an actual written agreement is something that's important to establish to be a service provider. So step one, when it comes to analyzing all your vendors, is one, which ones do I have a actual contract with? Okay, here are the contracts. Let me review the contracts as they're constructed now to see if there's anything in here that that shows that they are being limited in what they're doing with my consumer's data. Okay, there may already be language in there, but chances are there isn't, because a lot of times these things weren't reflected at the time that these contracts were developed. So you look to see there. So, okay, the language is not there. Well, then unfortunately right now, as it stands, you are likely not to be able to establish them as a service provider. And then there are some instances actually where if you review that contract, they even say explicitly, we reserve the right to take that information and use it for our own marketing or advertising. So it's actually the opposite of that. And when that happens, essentially what they become is not a service provider, but a third-party vendor of yours. And essentially when the consumer opts out, you would then have to ensure that opt-out is communicated to these parties so that they can, and then additionally, the consumer can also opt out from that relationship directly.
Yeah.
Stan, one way that I look at this provision is, there is a balancing act here, right? The legislature obviously wants consumers to be able to protect their data and their private information, but at the same time, they don't want to completely quash these industries, right? These data analytics, these web hosting, they don't want to quash them, and they think that if consumers can opt out and now their data cannot be transmitted or disseminated or shared, that it would impact those other industries in such a way that it may just, substantially put them out of business, right? So the legislature said, okay, you can still do all that, right? You can still use your web hosting people, your data analytics people. You can still do all that, and you don't have to get bogged down in this opt-out. But we're gonna fence you in, right? We're gonna fence you in what these service providers can do. One, there needs to be a contract in place. It needs to limit what they'll do with your information, and that's the balance, right? The consumer still gets, the primary business. They can opt out there, but this other kind of ancillary service, as long as it's kept in this tight little fence, can move on and can continue.
And when it comes to reviewing those vendor contracts, I know I indicated that some of them may have that language, some of them right now don't. So to the extent you making your own business decisions, think to yourself, I kind of want to make sure that this company is a service provider of mine. we need them to analyze this information, and we're pretty sure that they're not taking that information and selling it elsewhere, that they are really just doing it for our benefit, and then that's, you have that relationship with this third party, then essentially at that point you would likely need to draft up something that's referred to like an addendum to the contract, and then that this addendum would have that language, something to the effect of the information we're providing you, you're not going to then process it for any other purpose.
Or any other purpose, right? As we've been talking, it occurs to me that we're really talking about this slide, the next slide after the slide that was just on, going into a little bit more detail of what is a service provider and so on. We've been talking about this, that and I don't think we've quite gotten into exactly how the CCPA defines a service provider. But you've got the language processes information on behalf of a business. And why don't you say a few words about this piece? I mean, as I said, we've just been talking about this slide in some sense, but there's also aspects of the slide we haven't even touched on. So let's spend a moment or two and kind of catch up.
Right. So the purpose of this slide specifically is just to make sure that people understand that when it comes to that third party aspect, there's two important definitions that you need to break down. One, what exactly is a service provider? And then two, what is a business purpose? And if you recall from the last slide, that a service provider only processes your company's information for the business purpose. So here's the definitions for both that are taken directly from the CCPA. So a service provider is a company that processes information on behalf of the business and to which the business discloses the consumer's personal information for a business purpose, pursuant to a written contract, as we were discussing, provided that the contract prohibits the entity receiving the information from retaining, using, or disclosing the personal information for any purpose other than the specific purpose of performing the services specified in the contract. So that's sort of, to Stan's point, we were speaking about that in the previous slide, the idea that a service provider is meant to just process the information for the specific direction of the business, and that they're not going to do anything outside of that. And there's also a definition of what exactly a business purpose is, which is the short-term use provided that it does not disclose to a third party or used to build a profile of the consumer, and performing services such as customer service, order fulfillment, payment processing, advertising and marketing, analytics, and similar services.
So then,
which is where we came up with the examples from that last slide.
Right. And I just saw in here as well. So let's say I use a third party for payment processing. So that third party collects the credit card information, name, expiration date, zip code, whatever, of the consumer. So long as it's for, quote, a business purpose, that's their only use of it, then they do not retain, use, or disclose the information for any other purposes. Then they could be, if there's a contract, a service provider. Is that
correct? Okay.
Yeah.
And in all likelihood, yes. Again, as much as we can speak in indefinite terms when it comes to the CCPA, we're working only under the presumptions of what's been identified in the law right now and the proposed regulations. But from our understanding right now, yes, as long as they meet those requirements and there's a written contract, then they would be considered a service provider.
So real practically then, I'm thinking now SecureTheVillage, we've got a credit card processor. It's on us to make sure we review the contract that the credit card processor's given us, because we haven't written it. It's a standard contract, that they have. Make sure that the language there makes it clear that they're a service provider, not a recipient of the information.
You can review it. You can also have lawyers review it.
Well, that's true. Yeah. When I said we review it, I did not intend
Collective,
that
yeah,
would be for
collectively.
me to review it.
No, I know. I was just being.
Yeah. For me to go to you guys, or whatever.
And then with that, just making sure that whatever vendor written agreements that you do have, that you don't have that language in there. It's not too late. It's not like it's a sinking ship that this is automatically going to be a third party and not a service provider. There are ways that you can provide written addendums to that contract, and presuming that the vendor equally is of like minds of, yeah, we're not selling this information anywhere outside of just this relationship, and we want to keep this relationship. So we're going to agree to this written addendum, restricting our use of this information.
And to your point, that's already what their behavior manifests. I mean, they're not sharing it. I'm thinking again of a credit card processor, whatever. So it doesn't interfere with what they're already doing. It doesn't change that. It just documents and draws some lines around it. Is that right?
Yes, and if it does interfere with it, if they are a company that says, look, we are in the business of having this data, and then using this data for our own marketing purposes, our own advertising purposes, that's fine. It's just it then comes into the opt-out, then becomes affected by it. So again, none of what we're saying here is telling any specific company what they absolutely should or shouldn't do. We're more telling them, hey, this is the ramifications of the law, and it's up to the business to make those business decisions of, I'm willing to allow this to be a third party, or no, I need this to be a service provider.
Yeah. Matt, you have anything to add?
No, I mean, I think Weiss's point is a good one. What we counsel clients is, what is your business? What do you do with this? And we'll tell you how to best navigate these admittedly evolving restrictions, right? If you've got a service provider that is using this stuff and you know it and they know it and everyone's okay with it, that's fine. That's not prohibited by the CCPA, but that just means that if you get an opt-out, it's expanded to them as well. So you just have to comply with that. That's fine too. So there is some flexibility there as long as you kind of go in eyes wide open and you know what your obligations are depending on your usage.
Yeah.
And honestly, that is what helps companies comply with the law in general, because this specific requirement forces companies to take a look at all their vendor agreements and review these vendor agreements and see exactly what information is being given to them and what they're doing with that information. So indirectly, this thing benefits companies in terms of understanding truly where their information goes, and provides something that we're calling like data mapping, which has been a key component in ensuring that companies are being CCPA compliant.
Right. Yeah.
And you'd be surprised by how much people are learning what information they're giving and what information is being processed, that this law is helping companies understand.
Yeah. No, and as you both are talking, I'm seeing a clear parallel to, it's not the lawyer's responsibility to tell the business how to do its business. It's just given the business, here's how you need to think about navigating the legal landscape. you know, as it is, whatever. And that's very similar to us. It's not our responsibility as information security operations folks. I mean, that's what our company does. It helps with. It's not our responsibility to tell the client how to do their business, but given how they do their business, how do you take the body of information security knowledge, the NIST framework, and things like that? And CCPA, we'll get into the private right of action in a moment, and reasonable security practices. All of it, the data mapping. How do you take all of that? And given the nature of the business, how do you operationally navigate that field, that field of play, if you will? I'm hearing very strong analogs between what you're talking about from the legal perspective and what we talk about from the operations perspective. It's both. Okay, here's the landscape, here's the playing field, here's the realities of it. How do we navigate it so that you get to do what you got to do in the most optimal way, and yet you're still appropriately, as you feel the need, complying with CCPA or your information risk? I mean, what's your risk tolerance comes into play in these kinds of situations as well.
Yeah. No, certainly. I mean, it's especially when it comes to this aspect of the law, because it also involves a lot of relationships that these companies have with their vendors, because ultimately they're going to be the ones to contact their vendors when it comes to getting an addendum signed and things like that. So yeah, the best that we can do right now is just sort of provide them what the requirements are and indicate to them, if you go this path, this is what's going to happen. If you go down this path, this is likely what's going to happen. And then ultimately it's up to the business to figure that out.
Yeah. Very, very good. I find this fascinating. This, it's a small piece, if you will, of this big law, but it's like, whoa, there's some real meat here, real stuff to get your fingers around, that way.
Yeah. I mean, and data mapping is a very useful exercise in general, just because it really does cause you to evaluate where your information is going.
Yeah. Oh yeah. We find it for us, again, on the operational side, it's so valuable because it's something that the better you understand where your data is, how it flows, who's responsible for assigning access rights and all of those things to it, the better able you are to protect it that way, because now you better understand it. And that push, that force, if you will, from CCPA that's pushing you to do that, just adds to the quality of your security management when you actually begin to implement those things. So yeah, absolutely. Let's move on to the private right of action. That's a whole other big piece of CCPA. And frankly, it's the part that I like the best because it leads into reasonable security practices. And I'll own that. But go ahead. Let's talk about private right of action.
Yeah, so as we mentioned a little bit earlier, there is a limited private right of action in the CCPA. Essentially, it provides a private right of action for consumers whose non-encrypted and non-redacted data is, stolen, hacked, what have you. Now, it's important to note not all violations of the CCPA are subject to this private right of action. It's limited to when there is a data breach and your information is out there. There are statutory damages. They're listed up there on the slide. Not less than $100, not greater than $750. That's per consumer, right? So if this is a massive data breach, you can imagine that adding up really quickly. The one kind of curious thing that we've talked about internally is this cure period. Businesses do have a right to cure. They have a 30-day notice before you file a lawsuit, and they can cure. Given the limited private right of action is when there's been a data breach, I don't know how that gets cured. I don't know how that happens.
Yeah.
So that is a curious insertion into the statute, but it's there. But you do at least need to get the 30 days written notice. So, and I'm going to skip to the last point, and then I'm going to move back up. But there have been efforts, numerous efforts, to expand this private right of action to any violation of the CCPA, right? The opt-out provision or anything like that. Those have all failed so far, but those continue. So that's something to watch. Now, and Stan, we've alluded to this a few times already. There is a defense available to a action under the CCPA, and if a company maintains reasonable security procedures, that is a defense to this private right of action. So essentially, how I look at it is a data breach is not going to be a strict liability offense, right? If a company gets hacked and there's a data breach, that doesn't automatically mean that they're going to be liable to all these consumers under this private right of action, right? That's not how it works. If that company maintained reasonable security procedures, then that provides a defense, right? Now, reasonable security procedures is not defined in the CCPA at all. So what does that mean? That is a I think you've done separate webinars just on what that means, and we'll talk about it a little bit. My personal opinion is that definition, that term, will be litigated, and it will depend. It'll be a different answer for the Googles of the world than for the mom and pop restaurant down the street, right? It'll be a sliding scale, and it'll be litigated, and you may get different state courts at the trial level having different interpretations. It may go up to the appellate level. It may go up to California Supreme Court. So we get some clarity, because there is no clarity right now on what that means. I think that's one of the big debates about this law, and because if businesses are saying, okay, what do I do, right? I don't want to be sued. What do I have to do? It's not as simple as here's a checklist, 1 through 10. It's not that simple because of this term, reasonable security procedure. Yeah. But that's where a lot of the discussion is in connection with the CCPA and compliance. It's going to continue to be that way, I think, until we start getting some clarity on it.
It may also be reasonableness might also be determined by a jury, and in which case then you will be trying to convince a jury of lay people who may have different understandings of computer technology and information technology, determining what is or what is not, what was or was not reasonable.
Yeah. Yeah, I want to move on to this next slide because it's got some of the language as well for us to talk about. But yeah, you're both nailing it to me. I mean, absolutely right on. And your point, Weiss, around what happens when this gets to a jury is a very when we talk about cybersecurity and reasonable security procedures and so on, it's a great way for eyes to glaze over. It's like you're talking about what. That kind of thing, and to I don't know, to expect a jury to be able to get some of the nuances here just makes me very concerned, as someone who tries to help their clients meet reasonable standards of security. Yeah.
So yes, and that's a good point, and that is a challenge. When we're looking at what is reasonable, what isn't reasonable, I think one way to look at it is what is the floor, right? What is the baseline, the minimum that we need to do? And one way to think about it is there are other laws on the books in California that have been not part of the CCPA. They've been on the books. 2 of them are actually listed on your slide there that require businesses to either destroy, shred, erase consumer information when they're done using it, or that businesses need to maintain reasonable security procedures. I would argue, and I think it's a compelling argument, that if a business is not complying with these sections, right, that require you to do certain things, that is unreasonable, right? That may not make it reasonable, right? There may be more you need to do, but I think at the bare minimum, not complying with existing law is unreasonable. Right, and as we were having this discussion earlier today about the service provider, I can also make the argument that if you've got a service provider and you don't go back and you don't redo that contract and look at it and ensure that they're not selling that data now that the CCPA is out, maybe that's unreasonable, right? Now, if you know what they're doing with your data and you don't go back and dot the I's and cross the T's, maybe that's unreasonable.
Yeah.
So providing that baseline provides some help, I think, to our clients and to businesses. They'll say, okay, I need to at least do this. I may need to do more, but I need to at least do this.
Yeah, yeah, and yet, yes, and if you will, because I look at the two quotations from the law that we've got here from 1798-81, and the first one says a business shall take all reasonable steps to dispose, blah, blah, blah. The second says a business that owns blah, blah, blah shall implement and maintain reasonable security, blah, blah, blah. And so we've got a definition of reasonable that loops back on the word reasonable. And I learned back in the 3rd grade, I think it was, maybe the 4th grade, that you couldn't use the definition, you couldn't use the word you're defining in the definition. That you haven't said anything to do that. So this kind of, I see this is in some ways even a minefield waiting to be kind of, chaos waiting to be ordered. Maybe.
Yeah, and it's somewhat, and to your point, Stan, it's somewhat circular, right? It's reasonable if you've acted reasonably. You know what I mean? It is circular, and that is going to need to be sorted out, so to speak.
Yeah. And it's also, it's circular, and it makes people wonder, like, well, if it was so reasonable, how did it get breached? So there's always that struggle, because and something that, going to SecureTheVillage events and things like that, there's always an understanding that it's not a if it happens, it's a when it happens, because inherently within every computer system, there are humans involved, and humans are prone to make mistakes, and that the mistakes happen. So we've outlined on the bottom, on the last bullet point, these are just essentially when it comes to building an argument that your practices were reasonable. Essentially what you're doing is building a narrative, right? You want to be able to convey to either a judge or to a jury or someone that you've been acting reasonably. And with that, you need to have what are the steps you took to ensure that something was being reasonable. And we just outlined some very general concepts, which is, we've had periodic risk assessments. We've had an internal, external penetration test. We've had, we've done these steps to make sure that our procedure and practice, our security procedure and practice have been reasonable. So really, you're building the story that you want to then convey to a judge or to a jury or to opposing counsel if there's a litigation that had occurred.
Yeah, and I'm going to move on to the next slide. What I've got here on the slide now is this is what we collectively at SecureTheVillage have kind of put together, and it's documented. There's the link to it there as a set of minimum reasonable security practices. I mean, you mentioned risk assessments and penetration testing as illustrations of that, but I think the key thing you said, Weiss, that to me is what's the narrative? What are you doing that lets you say, okay, these are the things we're doing. Here's the basis on which we believe these to be reasonable. And here's the things. And we brought them down to 9 specific things here. We're looking at, are you managing this stuff from the top? Look at the first and the last one. Is there executive management, and is management govern? The executives, are they governing the program? Do you have subject matter expertise? We find when we go out in the world, a lot of companies that don't have subject matter expertise. They're kind of winging it with their IT vendors. The whole point about security management of sensitive and private information, that's the data inventory. That's that piece, making sure you've got that covered. Are you training your people? Are you trying to work to build a secure culture? At the very minimum, doing annual training of staff. Are you managing access to the network? That's the top one on the right-hand side. And are you managing the security of the network itself? Are you patching your systems regularly, and so on? Critical to the whole discussion around service providers is third-party security assurance. What steps are you taking to make sure that your third parties are protecting the information that you're providing them. Resilience is the new term. People may not be familiar with it, but that's all around backup and recovery and your incident response plan and your business continuity plan and those things. And we feel that a program based on these 9 things, and there's more details on the Secure the Village website for what all this means, like a great deal of detail, but this forms the basis of being able to make that narrative for you. And I think this is one of those great places I'm going to pitch Secure the Village. And, I mean, you guys have been a part of us for now quite a while, and, been very generous with your office. I mean, we meet at your offices regularly and so on. I mean, so you guys get it, that this is the intersection of, if you will, law and operations in this brand new field. So, I'd like to kind of suggest that we in Secure the Village collectively have a sense of what all this means. And to your point, we're not going to see it play out in lawsuits with juries. Matt, to your point, to the appellate court, to the Supreme Court, until finally we get a resolution that is somewhat really definable as to what this stuff means. Yeah. Right. So
if we ever.
If we ever. That's right. That's right. If we ever. Yeah. Kind of wrapping up then. So, there's the resource kit. There's this webinar, and the PowerPoint slides will be on there certainly by the beginning of next week. And there's a lot of other information as well on the in the resource kit. We've built that to be a tool for companies to use in managing their information security, whether it's the legal side, the operations side, the insurance side, all of that. And we'll be doing a second of these on the personal security side as well. That's something we're quite excited about. Our next webinar is April 9th. It's under development. One of the things we're thinking about doing, but we don't have confirmation of it yet. With the coronavirus, we're seeing the more and more people are being asked to stay home and work. So we'll be looking to, one option for April 9th is, okay, what do you have to do to secure your remote workforce? How do you manage that piece of it? And this is just a general, what are these webinars that we do? And they're all around providing management guidance around, just how do we navigate this space? I mean, Matt and Weiss, what we've just been talking about today is just, take CCPA as one illustration. How do we navigate it? What are the things we have to think about? The great quote of Einstein's that you can't solve today's problems with yesterday's way of thinking, and we need new ways of thinking, and that's what we're so grateful for both of you to have shared with us today on this. There's a lot we do. I'm not going to go through all the details. We've already mentioned the minimum reasonable security practices, but just for more information, you've got Matt's email and phone number and Weiss's email and phone number as well. So don't hesitate to call either or both of them for further guidance in these areas. And also think about signing up if you don't already get it. It's free. The Cybersecurity News of the Week that comes out every Sunday from Secure the Village. It goes out to several thousand people. And if you're not on that list, please feel free to get on that list. And beyond that, follow us on LinkedIn, attend an event. You can get our events calendar online. We're, again, with the coronavirus, some of our physical space events are already being canceled, sadly, but opportunity for webinars like this will always, hopefully, coronavirus or not, we can deal with those things. And if you're in the space of cybersecurity at all, like Matt, Weiss, both of you are, consider joining our leadership council. There's information on the website. So with that, final words, final thoughts, Matt, Weiss.
No, I mean, I think we covered a lot today. I think it was some valuable information. But a lot of it's to be determined, right? As we discussed, as recently as yesterday, this is an evolving area, so well advised to kind of stay up to date on it and stay ahead of it. But
Dan, I appreciate the opportunity to chat with you today. It's been good.
Yeah, cool. Weiss, yeah.
Yeah, no, to that point, today was a very surface level, airplane view of what's going on. In order to evaluate each individual business, it's important to review their own data plans or their data maps and things like that. But also want to echo, join the SecureTheVillage group, the leadership council, and you get to hang out with cool people like us.
Yeah, cool. Very good. Yeah. No, and we're grateful for truly, frankly, all the support that you guys and Buchalter have been to us as we've grown. And I'd just say final words, if you will. I mean, this is complex stuff, to what you alluded to earlier. This is not a time to go it alone. This is a time to get your attorneys involved, make sure that you've got these pieces covered. Because the consequences, as we've seen, can be quite serious. And the same on the cybersecurity operations side. Make sure that your security people have this stuff under control. And we've not had the insurance folks on today, but there's a piece of this that you can't mitigate all your risk with insurance. I mean, competitive advantage and so on. I mean, that's much softer than here's money for the money you lost, but you can protect yourself from that money loss as well with insurance. So be thinking about these things. Everybody, I just encourage in our audience to, it's this three prongs of, the operations piece, the insurance piece, and then Matt and Weiss, what you bring here, the insurance piece of the legal piece of it as well. So, don't try to do this by yourself. It's way too complex, if you will. So with that, let me just, go on to the final slide and say thank you all very, very much. Matt, Weiss, grateful to you both for being on the show, on the webinar, and to everybody else. So we are adjourned. Thanks.
Thanks, Dan.